Well, hello and welcome back to my channel. You're with Joanne, the learner lawyer. I am a law student from Australia, and I thought, as I was going about my business today, I was working, I saw that there was some filings. So I've seen what people have said about them. I've seen what Katie Joy has said about them. I haven't seen yet the full extent of the filings. I don't know how it's all written and all of that sort of stuff. So I thought I would do it as a first reaction of it. I have to have another X-ray tomorrow, and then I have to see a specialist tomorrow regarding my wrist. I don't know what's going to happen. I know it's still giving me a lot of grief. So, and it's very painful, but we'll see what they have to say tomorrow. So I wanted to, first of all, let's start and see, first of all, what Katie Joy said about it all, because she's been very, very vocal on her social media. Now, the thing about her social media, hey, Terry, how are you? The thing about her social media posting is that, from what I can work out, it looks like she's going to trial now. And the problem is, if it's a jury trial, she's dealing with people. And one thing that people don't like are people that are arrogant and boastful. I mean, we see that all the time. You know, they go, you just get put off by them. Now, I'm not saying this is how it's going to end up. I'm not saying that this is how it's going to be. I am just saying she's got to be very, very careful, because at the end of the day, it's people that you have to convince about things. And if you're too arrogant and you're too braggy, well, I know that I don't like them. So let's have a look. First of all, she posted lots of posts today. And as I said, it's up to you whether you think. We'll see what she's got to say, and then we'll see what the judge has to say. So this is what she posted earlier today. So she says, "You're at the Grammys. How did I damage your career?" I didn't. "So I'm being sued by these two via Robert Shin. They're posting sponsored ads and going to the Grammys. So how did I ruin their career again?" "Oh, wait, I didn't." "I never lied, contacted the LA Clippers, never spoke directly to sponsors, and reported on court records real-life accounts of the pastor you both follow." "Yet, despite all of the reports, you both continue to follow a man that has had dozens of people accuse him of terrible things. But I'm the reason your careers faltered, even though you're all at the Grammys. Flexing like this doesn't help your case at all." Well, I would argue, Katie, that posting like this isn't going to help your case at all. Hello, John and Amanda. Hello from the Netherlands. How are you? And then she says, so I had to do them over various screenshots. Then she said, "Flexing like this doesn't help. Looks like you are thriving. Yes, Miranda and James continue to follow Robert Shin and are still part of the group. Sad." All right. As I said, that is what she said. then she edited. Then there is another version, which was an edited version. So, well, I think the bragging could be a downfall because she's going to court now. Oh wow. -5. Oh, we've had the sun out today. I didn't have any air conditioning in the music room I was working in. It was very hot. So then she says, so someone says, who all has left the group as of now? Feel like Miranda and James changed their business info to make it seem like they still aren't under control. So then she posted this. Now remember, most of this, I have no doubt that the 7M lawyers are collecting this, and I would be on the phone to Mr. Martin, or I'd be on the phone to her lawyers. Now, if she wanted to make a statement, that's what you have lawyers for. That's what you're paying them for. She could have easily have said, this is from my lawyers. But she hasn't. She's done this. Sandwich strike again. Doesn't even make any sense. Big news for those that have been following my coverage of 7M and Shekinah Church. Robert Shin attempted to silence me through a temporary injunction which would have barred me from speaking on the topic. However, a judge in Minnesota ruled in my favour, denying his temporary injunction, citing his request as being a deviation from public policy. The Minnesota judge also ruled that Robert Shin, Miranda Derrick and James Derrick, along with the companies, are all public figures. Therefore, they must prove actual malice and that I deliberately lied about them in my coverage, which I have not lied or defamed anyone. Given this high standard, they have a significant higher burden to prove that I defamed them. The court also denied their motion for a default judgment. Shin argued that I failed to file a response and was therefore required to pay him $1 million. The judge ruled that while I was late for a single answer response, that my counsel continued to have conversations with his attorney in the days leading up to their motion for default judgment. The judge ruled that I responded within 1 day of their filing with my answer and met the burden of not being in default. Therefore, to proceed, he will have to provide us. It's interesting because she's done it all about what he has to do. He has to provide us with discovery, and a new schedule was set by the court. Some of the discovery will be marked confidential and not available to the public. Robert is suing 5 people in California for the same damages and injuries he's claiming against me, which will complicate his case here. The court has yet to determine in California if he's a public figure or not. Despite his best efforts, Robert hasn't bankrupted, silenced, or intimidated. I think it's supposed to be intimidated, but intimated. She's got intimated. And look, I'm going to make it bigger so that you can see this. Intimated. Isn't there... that's not how you spell intimidate. Intimated me. Robert hasn't bankrupt, silenced, or intimated me. I look forward to continuing to prove that I have not lied or defamed anyone. I hope that remaining dancers remaining inside the group will one day find freedom outside of this. Now, so that is her summary of it. What I have been able to ask now, what she actually has failed to mention in that, from what I've read on social media, is that her motion to compel, if you remember, she filed a motion to compel the motion to compel also failed, and the judge gave a new order. Now, for those of you that have been following me for a while, you would have heard me say that I had 2 reasons for why those dates was either... I had said that I thought that it would be going to trial. I said that when all the dates were made. So I said, I think you'll find the judge will. I wasn't sure how the judge would go with the protective order. Now, it is a partial protective order. So let's have a look at these and see what this law student came up with. So it's nice to know that I was right. I did pick it. I did pick it. So this is a protective order. This is to say that you are notified that on 7th of February the following is filed: protective order and order other. So what is interesting, in my opinion, is that it's a partial protective order. So what she said, it's interesting because it didn't necessarily fail. It's only a partial order. And so therefore there's a difference there. Hang on, only one of them came up. I just have to get the other one up. So what's everyone's feelings on this at the moment? Hang on. I'm still here. I've just probably disappeared temporarily because I've got to do this. What's that one? That's 11. I need 17. Hang on. I'm just going to pull up document 17. There we go. Oops. And I'm back. Right, I'm back. Right. Oh, it's opened in the wrong spot. So let's look at the protective order. This is the protective order pursuant to Minnesota civil procedure. Now, as I said, it's only a partial order. So essentially, I'm waiting for it to load. Okay, we'll go with the other order. Oh, wait, here we go. This is the protective order. So 7M filed for protective order because they said, essentially 7M said to the judge, we'd like a protective order, particularly over, Plan to Create says, after watching. But is it a jury trial or is it a judge-only trial? This is the thing. And don't forget, this is the same judge that dismissed her motion to dismiss because she believed that there was some defamatory content there. Now, it is my understanding, or what would happen in Australia, is that you could appeal that decision. So I'm wondering if 7M could appeal the decision. I don't know. Because you could argue that in one judgment, the judge has said that it is defamatory, and then on the other side, so I don't know. Or maybe Her Honour just wants to watch these drunken Instagram lives. I don't know. So this is the protective order. So there is a protective order in place. So the court hereby adopts and enters this protective order as follows. I also heard that Uncivil wasn't very complimentary of the judge's decision either. But again, that's his opinion, and I've got no idea. I haven't read it yet, so let's have a look. So the court hereby adopts any party to this action may designate documents and information as confidential to protect it within the scope of Minnesota Civil Procedure 26.06. So it means that at any stage, either party can mark what they have filed as confidential. So they don't have to go to court anymore to argue over it's confidential. That means also, don't forget, that Katie Joy can mark her documents as confidential as well, which means that we may not ever get to see her financials. So let's just also put that into perspective. So it means that both parties have the option to mark any document as confidential. All right, so highly confidential, attorney eyes only, means and is limited to confidential information that constitute information that the producing party deems especially sensitive, and is limited to private financial information, sensitive and private business information, medical records, and personal contact information. Access to highly confidential attorney's eyes only material shall be limited to counsel of record only, and cannot be distributed to clients, the parties, or other individuals. So the judge has said that the highly confidential stuff for the attorney's eyes only is going to be the private financial information, medical records, personal contact information, and that only the attorneys can read that. They cannot tell. They can say to Katie Joy, we have the information, but they cannot. It cannot be distributed to her, so she will not get her hands on it. All confidential and highly confidential information shall be used solely for the purpose of this action. No person receiving such information shall directly or indirectly use, transfer, disclose, or communicate in any way information to any person other than those specified in paragraph 4. Any other use is prohibited. Again, the information is only to be used in this action. It means that if this action ends and let's just say Katie Joy decides to put the financial information out and it's come from this, it's a breach of an order. So the access to confidential information shall be limited to the court and its staff, attorneys for the parties, their law firms, and their outside vendors who agree to be bound by the terms of this protective order, persons shown on the face of the document to have authored or received it, and court reporters retained to transcribe testimony. So they're the people for confidential information. The highly confidential information, the parties, outside independent persons, persons not currently or formerly employed by, consulted with, or otherwise associated with any party, who are retained by a party or its attorneys to provide assistance as mock jurors or focus group members, or the like, to furnish technical or expert services, and or testimony in this action who agreed to be bound by the terms of the protective order. So that's for the confidential information. Okay? All portions of documents and information disclosed in a deposition by a witness may be designated as confidential information and therefore obtain the protections accorded other confidential information. Confidentiality designations for depositions shall be made either on the record or by written notice to the other party within 10 days of receipt of transcript. Unless otherwise agreed, deposition transcripts shall be treated as confidential information until the 10-day period following the receipt of the transcript expires. The deposition transcript of any witness or any portion of such transcript that encompasses confidential information shall be taken only in the presence of such persons who are qualified to have access to such documents and information. This is the important part. Any person who inadvertently fails to identify documents and information as confidential or highly confidential information shall promptly, upon discovering of its oversight, provide written notice of the error and substitute appropriately designated documents and information. Any party receiving such improperly designated documents and information shall retrieve such documents and information from persons not entitled to receive them. Upon receipt of substitute documents, shall return and destroy the improperly designated documents. The disclosure of documents and information that is later designated as confidential or highly confidential information under this paragraph to persons not having the authority under this protective order to receive them shall not, however, constitute a violation of this protective order if such documents and information are retrieved pursuant to this paragraph. I don't know what the Y is there for. Any party may request a change in the designation of any information designated confidential or highly confidential information. Any such information shall be treated as originally designated until the change is completed. If the requested change in designation is not agreed to. Hello, Denise. The party seeking the change in the designation shall, within 30 days of the requested change, move to the court for appropriate relief. The party asserting that the material is confidential or highly confidential information shall have the burden of proving that the information in question is within the scope of the protection afforded. So, any information, so if you have deemed something to be highly confidential, if they want to argue that out, they've got 30 days to do it. If they can't decide, then they've got to go to the court to decide, Within 60 days of the termination of this action, including any appeal or by way of settlement, each party shall either destroy or return to the opposing party all documents containing information designated by the opposing party as confidential or highly confidential information, and all copies of such documents, and shall destroy all extracts, notes, compilations, and all data files containing such information. Each party shall provide a certification as to such return or destruction within the 60-day period. However, attorneys shall be entitled to retain a set of all documents filed with the court and all correspondence generated in connection with the action. So, within 60 days, so they're saying about appeals and settlement, as part of the settlement of the action, they've got to destroy all the documents that aren't required for the official court, for the official file. Any party may apply to the court for a modification of the protection order, and nothing in this protective order shall be construed to prevent a party from seeking further provisions, enhancing or limiting confidentiality as may be appropriate. Additionally, no designation of confidentiality shall mean that the party making a designation is entitled to any presumption or determination that the information is protected under Minnesota law or by contract solely because of the confidentiality designation, except as provided by this protective order. No action taken in accordance with this protective order shall be construed as a waiver. This is full of mistakes. A waiver with a 3? Look, can you see that? This is very poor. Look at that. Look at that. Or any claim, I did hear that there are a few big mistakes in the judgment. Of any claim or defence in the action or of any position as to discoverability or admissibility of evidence. Nothing in this protective order shall apply to documents and information which may be designated as confidential or highly confidential information if the information is publicly available or lawfully obtained by a party from a person who lawfully possesses the information. The obligations imposed by this protective order shall survive the termination of this action. So, it means the protective order will still remain in place even beyond the thing of the action. So, at no stage, if anything's deemed highly confidential or for the attorney's eyes only, even if the action ceases, that stuff is still confidential. So, that's very interesting. So essentially, any party can deem any document confidential. We've got the list of confidential stuff. Then highly confidential stuff is financial records and all of that sort of stuff, and is only for the attorney's eyes only. So they will be wanting certain information, So they can now ask for it in discovery. It can be given. So that to me, so that looks to be quite fair in some ways, because, but it's for both parties. So the judge hasn't said only one side. She said both parties. This is what's going to be for attorneys only. This is what can be confidential. Here's how we get to it. So that seems to be okay. Right. So here we go. Here's the document that I'm interested in. Now, as I said, I heard the uncivil thinks the judge is on KJ's side. But, before we've thought judges have been on the other side and it went, so who knows? I got no idea, to be honest. So let's have a look. It's 14 pages. The above titled matter came on for a hearing on the parties' various motions on November 21, 2022 before the Honourable Michelle A. Davis, Judge of District Court. Plaintiffs appeared by and through attorney Amber Stavick, and defendant appeared and was represented by Christian C. Hendrick. Was it Christian Hendrick? Was it her, Kristen, or was it the other one? I don't know, because she had different lawyers, wasn't it? Due to COVID-19 pandemic, the matter was heard remotely via Zoom. All parties could hear throughout the proceeding. Based on all the reports, files and records herein, arguments of counsel, and after being fully advised, the court makes the following. The plaintiff's motion for default judgment is denied. And I find that that's very interesting that that's denied, even though the court actually put it on the file. Plaintiff's motion for a temporary injunction is denied, which is interesting because she's put in a protection order. Plaintiff's motion for amended scheduling order is granted. So, interesting. The parties shall abide by the following deadlines. So, it's interesting that Katie Joy was saying, they lost this and lost that and lost that. But there was three things there that were mentioned, and they got the amended scheduling order. So the deadline for service of discovery requests and filing all pleadings is now May 31. Let's have a look. Have we got new dates? We got new dates here? No, we haven't been there's no new dates. So I'll have another look in a minute. The deadline for joinder and of additional parties, whether by amendment or third party practice, shall be the 30th of June. The party shall provide a written designation of selected neutral to the court no later than 31st of July 2023. The party shall complete mediation by August 31, 2023. So it's interesting that the judge is still throwing mediation out there. Non-depositive motions shall be served and filed no longer than September 29. Hello, Bo. Dispositive motions shall be served and filed no later than October 31. Pre-trial conference shall be held on a date to be scheduled after October 31. Defendant's motion to compel is denied as premature, which I think is really interesting. Again, she's not said that. It's premature. The plaintiff's motion for a protective order is granted in part. Now, again, that's interesting. If you want to look at the motions, the plaintiffs had 2 granted. The defendants had none granted, just stating. The protective order will be set out by separate order. We said that, and the memorandum, and a copy of this shall be served on both parties. Okay. So now we've got the background here. All right. So I want to see what you think. So we looked at what KJ said. I mean, from the tone of her email, she was saying it all her way. It didn't go all her way because it didn't go all her way because she didn't get her motion to compel, and they got a new scheduling order, which is what they wanted and they did want. So things are in favour of 7M at the moment, in my opinion. Okay, so background. On the 31st of March 2022, plaintiff 7M Films Inc. and Robert Shin, which are a talent management company and its CEO as the sole owner, respectively based in the state of California, commenced a lawsuit against Catherine Paulson and Without a Crystal Ball a Minnesota resident and Minnesota corporation, respectively. Miss Paulson runs several social media accounts. Oh, gee whiz. My computer does not want me to read this. Social media accounts with substantial reach, numbering in the tens or hundreds of thousands of followers, and attendant engagement, particularly on Instagram and YouTube. The complainant was amended just days later on April 5, 2022, adding Miranda and James Derrick, husband and wife, as associates of Mr. Shin as plaintiffs. The amended complaint pleads 9 causes of action. The 9th count is mislabeled as count 10 against Miss Paulson and her LLC, but counts 1 and 2, defamation per se, respectively, ultimately underlie the remaining counts. Plaintiffs allege that Miss Paulson, via her Instagram page and other social media, defamed plaintiffs by posting false statements about 7M and associated individuals. Plaintiff's business is in the field of social media communications and marketing, as well as brokering deals between performers, particularly dancers and commercial venues. Defendant, in her social media posts, as listed by plaintiffs, claim that the plaintiffs, in addition to their commercial ventures, are involved with Shekinah, that's also spelt wrong, church, which plaintiffs claim the defendant characterises as a cult. Plaintiffs claim that the defendant has acquired and published court documents from litigation involving plaintiffs which were subject to a protective order, as well as that the defendants claiming that the plaintiffs engage in criminal conduct, including human trafficking, waterboarding, and kidnapping. Plaintiffs' other claims are rooted in the same allegedly defamatory conduct by defendant, but are pled as tortious interference with contracts, intentional interference with prospective advantage, deceptive trade practices, negligence, and intentional inflection of emotional distress. Defendants brought a motion seeking dismissal of plaintiff's complaint for failure to state a claim on which relief may be granted, which was denied by this court's order of August 24, 2022. In my opinion, it's the human trafficking, it's these allegations that I really want to see how KJ is able to prove those. Because all the evidence shows that they're the claims that she's made. How does she prove her human trafficking? How does she prove waterboarding? How does she prove kidnapping? But the question is, are those claims, can you deem those claims to be malicious? I don't know. All right. So on August 26, 2022, plaintiffs brought a motion seeking a temporary injunction against defendants' continued posting about the incident matter on social media, or in the alternative, for a disclaimer on each post that there is an active defamation suit ongoing. For a protective discovery order under Rule 2603, and for an amended scheduling order to extend the timeline for discovery in light of the motion for protective order. On October 4, 2022, plaintiffs brought a motion seeking default judgment on the basis that the defendants did not file an answer within 14 days of the court's answer denying defendants' motion to dismiss. On October 31, 2022, defendants filed a motion to compel discovery, seeking an order that plaintiffs provide an immediate response to the defendant's first set of interrogatories and a document production requests, along with attorney fees for bringing the motion. The parties timely filed responsive motions to all outstanding motions. It's interesting that she said it was timely. See, I would argue. Now, you can appeal if you can find points of law as an issue. So, interesting. If I was 7M, I would be scouring this and seeing if you could pick up the judge, whether she's interpreted the law and appeal the decision. Remember, you can appeal decisions. I'm not 7M. The rules of civil procedure provide that the defendant shall serve an answer within 21 days of service after the summons upon that defendant. However, if the defendant elects to respond to a summons served upon them via a motion under Rule 12012, A responsive pleading to a summons and complaint shall be served within 14 days after service of notice of a court's action, in the case when the court denies the motion. The rule concerning default judgments provide that when a party against whom a judge for an affirmative relief is sought has failed to plead or otherwise defend within the time allowed, therefore, by these rules or by statute, and that fact is made to appear by affidavit, judgment by default shall be entered against that party. Minnesota rule. This is where they could, if they argued well enough, they could possibly overturn the decision. The court may deny a motion for default judgment if the defendant has reasonable defences on the merits, defendant has a reasonable excuse for failure to answer, the defendant acted with diligence after notice of the entry of judgment, and no substantial prejudice will result to the other parties. And she's quoted there, Collar versus Guardian Angels Roman Catholic Church of Shaskra. And then Finden and Klaas, all four of these factors must be satisfied in order to justify relief under the rule. Well, that's what I was wondering, Terry, whether the judge wants to see these drunken lives. I don't know. Notice of the court's filing of its order denying defendant's motion to dismiss was served upon the parties' counsel on August 25, 2022. See notice of filing order dated August 25. Accordingly, defendant's answer would be due on September 8th, 2022, and no answer was filed by that date. However, by their conduct in the matter, defendants have clearly pled or otherwise defended the action within the meaning. What? I've never seen an answer. All right. Analysing the factors set out in Collar, the court finds the defendants met all these factors. As discussed, despite plaintiff's complaint, pleading 9 separate counts, the heart of the matter is plaintiff's count 1 or 2, which are claims for defamation. To prove that a claim for defamation, the plaintiff must prove the statement was false, that it was communicated to someone other than the plaintiff, it tended to harm the plaintiff and lower him or her in the estimation of the community. Which you would say, yes. In this matter, by their conduct and nature of their business, plaintiffs are almost certainly public figures. Interesting that they've said are almost certainly. The judge hasn't here said that they are public figures, and this could be a very good point that will be argued. And again, KJ said in her post that the judge stated they were public figures. Judges said almost certainly public figures, which requires a heightened showing of actual malice to prove a defamation case. New York Times versus Sullivan. Furthermore, defendants are plausibly a journalistic outlet which enjoys a qualified privilege against defamation claim. Accordingly, the court finds that defendants have a reasonable and a substantial defence on the merits. Plausibly? Plausibly. Again, she hasn't said that there is. It could be plausible. Interesting. Again, another point that would be very, very strenuous, that there would be huge arguments over. Because I would argue that if you're going to go down the journalistic standards, then we have to be talking about the journalistics code of conduct. And while there is a qualified privilege, I don't know how qualified privilege extends to waterboarding. So let me just say, defense of qualified privilege permits a person in a position of authority or trust to make statements or relay or report statements that would be considered slander and liable if made by anyone else. So to qualify for this defense, a report is required to meet one of the public meeting or press to qualify for this defense, a report is required to be one of a public meeting or a press conference that is fair, accurate, published without malice, subject to the right of reply in the form of a letter that explains, that gives explanation or contradiction. It need not be contemporaneous, depending, and it has to be for absolute privilege. So again, this qualified privilege, again, I reckon I could argue that her reporting does not meet the standards of qualified privilege. Is saying that sandwich strikes again, does that meet qualified privilege? Is that fair? Is that impartial? I don't know. And again, it says reasonable and substantial. So again, that's what qualified privilege is. But again, I don't know how she's going to argue that waterboarding and human trafficking falls under. Anyway, with respect to the second factor, the defendants have a reasonable excuse for their failure to answer. Defendants argued that they were anticipating further order from the court, giving them a deadline to file an answer following the court's denial of their motion to dismiss. While such an order may be customary, Rule 1201 provides clear instructions to a party whose motion to dismiss pursuant to 12.02 is denied. However, defendant also argues that they were taken away from their office in September 2022 due to a family emergency, which the court finds is a reasonable excuse for their failure to answer. Moreover, from correspondence between counsel supplied in their affidavits, it is clear to the court that the parties were engaged in active communication concerning the matter in the time period in which the defendant's answer was due, evincing an intent to continue to defend and participate in the matter. The court finds the defendants have a reasonable excuse for their failure to answer. It still doesn't explain why, if he was sending emails, why he couldn't have just sent the court documents. But anyway, with respect to the third factor, court finds that defendants acted with due diligence following the notice plaintiff's motion for default judgment. Plaintiffs filed their motion for default judgment on October 4, 2022. The very next day, defendants filed an answer. A gap of a single day is clearly sufficient due diligence supporting relief from a default judgment. But that's the wrong document. They sent off their answer. They answered the It was the one that they were supposed to file way back. It was the answer that they filed. They didn't file an answer for the default judgment. They said their answer for the claim. So it wasn't a gap of a single day. Gee whiz, can I appeal this? Finally, the court finds the plaintiffs would not be prejudiced by failure to grant default judgment in this matter. The gap between the defendant's answer was due pursuant to Rule 1201 when it was filed some 27 days. In that time, as discussed supra, the parties were communicating amongst themselves concerning the litigation. Furthermore, by the time the defendant's deadline for filing an answer, plaintiffs had filed motions seeking temporary injunction, in protective order and amended scheduling order, which would strongly indicate to the court the plaintiffs intended to continue litigating the matter without respect to the defendant's failure to answer their summons and complaint. Because defendants have made a showing on all 4 Collier factors, the court declines to grant the plaintiff's motion for default judgment. Seriously. What if it was, so they've credited the wrong, so she's talking about they answered within a day. It was the wrong document. Temporary injunctions are governed by the rules of civil procedure. So here are the rules. No temporary injunction shall be granted without notice of motion or an order to show cause to the adverse party. A temporary injunction may be granted if by affidavit, deposition testimony and or oral testimony in court appears to be sufficient grounds. Before or after commencement of the hearing on motion for a temporary injunction, the court may... Let me just say, they only filed the answer to the original claim because of when they got the default judgment thing, they've gone, oh no, we're in trouble. They didn't care before. I'm really mad, actually. Oh, anyway. So in order for a temporary injunction to be granted, the proponent must show that the other legal remedies are inadequate and that the injunction is necessary to avoid irreparable harm. Medtronic and Advanced Bionics. The irreparable harm must be established by verified affidavits or pleadings. Temporary injunctions are meant to preserve the status quo pending or adjudication on merits. Because the applicant is asking the court to preserve the status quo until trial, the applicant must have a valid underlying cause of action to proceed to trial. The failure to show irreparable harm is by itself sufficient grounds on which to deny a temporary injunction. So, when determining the temporary injunction, restraining order, court considers the nature and background of the parties' relationships before dispute, the relative harm to the parties if relief is granted or denied, the likelihood of success on merits, public interest, and the administrative burden on the court to supervise. So, plaintiffs argue that postings on social media concerning plaintiffs and their associated entities constitute irreparable harm. A loss of business and consumer good A loss of business and consumer goodwill can constitute irreparable harm. Overbolt, so there's some cases there. Plaintiffs allege defendants' postings have resulted in a loss of business contracts, and while other valuable payments, particularly a contract to provide entertainment and online influence with the Los Angeles Clippers, an NBA team, defendants do not seriously contest that plaintiffs suffered irreparable harm based on the defendant's social media postings, only arguing that the conduct is not itself defamatory. Addressing the first Dahlberg factor, the nature and background of the relationship between the parties is concerned with maintaining the status quo pending a decision on the merits. Prior to the dispute, neither party alleges the relationship between them existed. Plaintiffs were engaged in business in their state of California. Defendants were running social media pages covering celebrity and entertainment news and gossip. Therefore, she's not a journalist! Bingo! The defendants were running social media pages covering celebrity and entertainment news and gossip. The court finds this factor to be neutral. The balance of harms is the most important factor in determining whether an injunction should be issued. Plaintiffs argue that they are suffering irreparable harm as a result of the defendant's social media posts, and that any harm to defendants by being ordered not to post about the plaintiffs is minimal. As discussed, super defendants do not seriously contest that there is irreparable harm. However, in the form that plaintiffs are seeking will constitute a prior restraint of speech, which are generally unconstitutional absent exceptional circumstances. So any system of prior restraints of expression comes to this court bearing a heavy presumption against its constitutional validity. Furthermore, defendants argue that they are far from alone in posting the sort of objectionable content about the plaintiffs which plaintiffs allege is defamatory. Many other media outlets have covered the plaintiffs in negative light. The court finds that the balance of harm, the injury to the plaintiffs from defendants' social media postings, as compared to the burden of prior restraint imposed on defendants, weighs heavily against a temporary injunction. Don't forget, when they go to court, 7M's lawyers can show that the other media outlets only reported what Katie Joy was posting, that it's all stemmed from her. They're able to do that. They can actually probably, if I was them, I'd be subpoenaing the other outlets to find out how they got their information. Because if all roads lead back to Katie Joy, she's gone, in my opinion. With respect to the third Dahlberg factor, the likelihood of success on the merits, it is error to grant temporary injunction relief for a proponent cannot show any likelihood of prevailing on merits. As discussed, super plaintiffs almost certainly must prove the defendants acted with actual malice to prevail on their defamation claims. And defendants lightly can avail of qualified privilege against defamation claims based on their journalistic endeavours. Plaintiffs have a steep mountain to climb while bearing a heavy burden to prove their defamation claims against the defendants, and while the record submitted to the court at present juncture does not categorically show the defendants do not have any likelihood of prevailing on the merits, the court does not consider their claims to have substantial likelihood of being proven. Accordingly, this factor weighs against the temporary injunction. So they're essentially saying that because Katie Joy may be able to use qualified privilege, and because they've said they could be deemed to be public figures, then it's likely that they're not going to win. That's what they're saying. So yes, they're saying there is a good chance Katie Joy may be able to win because of the fact that, and don't forget, this is one judge's opinion. As I said, if it was me, I'd be appealing it myself. But anyway, yes, actual malice. And don't forget, it says, likely. So thanks, Joe. I look forward to hearing the rest in replay. Have a good day. All right, see you later. Thank you, John and Amanda. So they've only said lightly. Like, for me, the fact that the judge has not come out and said they are public figures and that she is a journalist, it says likely, which means that they're up for debate. It's all up for debate. But I would be, as I said, I would be appealing this judgment and getting these, but anyway, as I said, that's just me. But they've got a partial injunction. I mean, they may say, well, let's just leave it and we'll argue all these matters at court. The fourth Dahlberg factor concerns public policy and interest in the subject of dispute. To do so, the court must ascertain whether there has been a legislative expression which manifests a public policy on the subject. In this matter, concerning alleged defamatory statements and a request to enjoin defendant from speaking about plaintiffs, public policy is clearly against such a restraint, as demonstrated by the robust protections for freedom of speech provided in the United States and Minnesota Constitution. While society has a persuasive and strong interest in preventing and redressing attacks upon reputation, an action for damages is the only hope for vindication or redress the law gives to a man whose reputation has been falsely dishonoured. Milkovich versus Lauren. Plaintiffs have a remedy for defamation if proven through an award of damages at trial. To impose a prior restraint on defendant's speech in the interim, however, is clearly against public policy, and the fourth Dahlberg factors weigh against an injunction. Finally, the administrative burden imposed on the court in enforcing a temporary injunction against defendants is likely high. Plaintiffs seek an order enjoining the defendants for publishing or republishing on the internet, websites, forums, blogs, social media platforms, or otherwise the following material regarding plaintiffs. And lists a 10-item long list of allegations about plaintiffs' conduct. Defendants raise a salient point that social media postings are frequently reposted and linked back by other content creators, sometimes without attribution. Well, we know she's the queen of not attributing anything. It is not clear to the court how its order for temporary injunction could be enforced without substantially burdening judicial resources in addressing potentially limitless social media posts. Accordingly, the fifth and final Dalbert factor weighs against an injunction. Plaintiffs seek a protective order with the following terms. All responses to interrogatories, document requests, and requests for admission shall be viewed at counsel for the plaintiff's office. Counsel for the defendant shall be the only ones allowed to review discovery, take notes. Cell phones and other recording devices shall not be permitted in the room. All depositions and resulting transcripts shall be confidential, and the contents thereof shall not be disclosed to anyone other than the parties in this matter and their counsel. And so, therefore, now she goes through the rules here. In general, and it does say that discovery may be had only at unspecified terms and conditions, including a designation of a time or location. That discovery may be had by a method of discovery other than selected, that certain matters may not be inquired into. So it lays it there, and if the motion for protective order is denied in whole or part, the court may, on such terms and conditions as are just, order that any party or person provide or permit discovery. So again, the moving party has the burden of proving that justice requires the granting of a protective order, because if the discovery sought is permitted, the moving party will suffer annoyance, embarrassment, oppression, or undue burden or expense. So then we've got the court rules. So in this matter, the protective order sought by the plaintiffs is wildly overbroad. It seeks to limit plaintiffs' propoundment of discovery to plaintiffs' counsel officers, with defendants themselves not permitted to see the discovery at all, and defendants' counsels not permitted to make copies. Such a limitation would cripple defendants' ability to defend their interests in the matter and become a vehicle for the suppression of relevant and essential evidence. Although the suggested terms of plaintiffs' proposed protective order are clearly overbroad, their concerns over disclosing confidential information wholesale to the defendants have some merit. Yes, here we go. And it's interesting how Katie Joy left this out as well. Based upon defendants' prior history of posting litigation material involving plaintiffs in other legal matters, it is reasonable for plaintiffs to fear that should they turn over sensitive information to discovery, defendants will post the same on their social media pages. Accordingly, the court will enter a narrower protective order set by separate order, which will permit plaintiffs to designate certain discovery disclosures as limited to defendants' counsel's eyes only, and cover other disclosures with a prohibition on disclosure to parties outside the litigation. It's interesting that they've said that it was a reasonable fear because somebody can't stop their fingers from posting. And as we've seen, that's exactly what she's done. Hi, why is your last one about bras? No, really? I don't know. I don't know why my last one about bras is no longer up. I haven't taken it down. Did someone delete it, did they? Hi, Vidandra. I haven't taken it down, Kel. Really? That's a bit of a worry. I'm doing all right, Angela. How are you? Let's have a look. I don't even have a copy of it. I haven't been told, Kel, that it was taken down. Interesting, isn't it? Okay. So the plaintiff's motion for an amended scheduling order. The rules of general practice provide that a scheduling order pursuant to this rule may be amended at a pre-trial conference or upon motion for good cause shown. Except in unusual circumstances, a motion to extend deadlines under a scheduling order shall be made before the expiration of the deadline. In this matter, a scheduling order was issued by the Honourable Carrie Willis on the July 13. I was looking to watch it again but can't find it. Yeah, it's under the live tab. Cal? YouTube's changed the way that stuff's done now. So if it was a live video, it's under a live good. Yeah, 7M trial will be pre-trials October 2023, after October 2023. Might be the end of the year. Maybe I'll be in Minnesota for Christmas. Hey, that would be good. Would it be good to go to Minnesota for Christmas? Plaintiff's motion for amended scheduling order concerns primarily a deadline set for service of discovery requests, which was stated in the scheduling order as August 5, 2022. While plaintiffs filed their motion seeking amendment of the scheduled order on August 26, 2022, the court finds that circumstances justify granting their motion despite the motion being filed after the scheduling order's deadline for discovery. Because the court was unavailable for a scheduling conference in the relevant period, given that the plaintiffs had sought a protective order to cover their responses to defendants' discovery requests and were understandably reticent to provide discovery without a resolution to that motion. The courts find that the plaintiffs have shown good cause to amend the scheduling order's dates to permit both parties to engage in discovery. Defendants' motion to comply. Defendants moved the court for an order directing plaintiffs to respond to a set of interrogatories and requests for the production of documents which they sent just prior to the scheduling order's deadline for service of discovery requests. The rule of civil procedures provide that information is discoverable in any non-privileged matter that is relevant to any party's claim or defence and proportional to the needs of the case. Considering the importance of the issues at stake in the action, the amount in controversy, the parties relative across to the relevant information, the parties' resources, the importance of discovery in resolving issues, and whether the burden or expense of the proposed discovery outweighs its benefits. In this matter, it is likely that the information sought by the defendants in their first set of interrogatories is discoverable. However, as discussed plaintiffs were actively seeking a protective order covering some or all of the discoverable information sought by defendants. Plaintiffs do not apparently oppose disclosing the information sought by the defendants, but are awaiting the court's decision on their motion for a protective order before disclosing their responses to defendants' discovery requests. With this order, plaintiffs addressing plaintiff's motion for a protective order and amendment to scheduling order, the court finds the defendant's motion to compel is premature and so denies it. Should defendants have further difficulties procuring discoverable information from plaintiffs, they may bring a new motion to compel. Now, what hasn't been discussed there, because the request was also for costs. So I don't know how the costs and everything work out. So what's interesting in that? I think the fact, for me, it's the fact that Her Honour has said that they could be public figures is very important. And that the fact that Katie Joy could rely on journalistic privileges, but see, even under qualified privilege, even in reporting, it still has to be fair reporting and a true record of reporting. And I still maintain her waterboarding, her human trafficking claims are going to be the hardest ones for her to defend. I think there's going to be a lot of argument over whether or not she's a journalist and whether qualified privilege will be able to be existed. The fact that Her Honour has said that it would seem on the face of it that she does have a defense. And don't forget, it's on the assumption that she is a journalist and that they are public figures. So I think the first part of the trial, or at the pre-trial conference, could be arguments over those parameters, because how does she prove that she's a journalist? Have a look at her. She doesn't write for any major. She has no blog posts. She's just a gossip, as Her Honour wrote in that document. She does celebrity news and gossip. Does that make you a journalist? This is all the stuff that. So, I'm really not sure. All I'm going to say is that, well, I think I would have a bit of an argument over the judge and the saying that they responded in one day bit. I think, I don't know. I'd probably appeal it. Remember, it's about, when it comes to facts of law, Her Honour admitted that it was 23 days. It was well over the time period. And the fact that he was emailing was immaterial, in my opinion. Well, see, that's my point, Cal. Where's her... that's right. Where is... But see, that's why she said likely. Where is her qualifications? She doesn't have any qualifications. She's got a Spanish degree. You know? So I'm just very interested to see how this is all going to play out. And you know what? If 7M lawyers are watching, ask for her journalism qualifications in discovery. That's what I'd be asking for. If she wants to use qualified privilege as a journalist, prove to me that you're qualified to be a journalist. Because surely that would go a long way. What? And all of her stuff that she wrote for when she was doing blog posts, could she say, she are all are not around either. So yeah, I just don't know. But the fact that, see, at no point did the judge say that she was. She said likely. And I think it's those you actually have to look at it all in context, I think. So just remember, I'm also just a law student. I have no experience in defamation law. I have no idea how Minnesota goes. But I think it's going to be very interesting. That's all right, Terry. Oh, gee. Wow. What qualifications? Well, you know what? They do university degree. There is a journalism course. They do journalism. I mean, and I'm not saying you can't be... But the thing is, if you are a journalist, you can... There's a code of conduct that you usually follow. You usually have a reputation in the industry. There's a whole pile of things that come up when you're a journalist that she doesn't have, in my opinion. So, I'm ashamed to, and the thing is, as I said, to be qualified to privilege, you need to also, let me just pull up qualified privilege. Have you noted big media? Yes, they do want to monopolize. Let me just give you the privilege. Oh, I'm certain it will. Now, don't forget, I'm going to the Australian defamation law. Okay. Yeah, oh, hang on. Qualified, let's look at qualified privilege Minnesota. Okay, oh, look. Let's see, remember Erin Hall, her first lawyer? This is what Erin Hall says qualified privilege is. All right, let's have a look. Erin Hall was her first lawyer. Wasn't he the friend from high school or something of hers? So let's have a look at what he says qualified privilege is. Qualified privilege protects defamatory statements made on a proper occasion, with a proper motive, and based on a reasonable or probable cause. Qualified privilege, in contrast to absolute privilege, protects only statements made without common law malice. Absolute privilege applies whether or not there was actual malice. Common law malice exists when a defamatory statement was made with improper motives, from ill will, or cautiously, or want only for the purpose of injuring a plaintiff. An example of qualified privilege exists to protect an employer from a potential liability for statements made about an employee, as long as those statements were made in good faith and for a legitimate purpose. Further, statements made regarding the investigation of a current or former employee are also considered qualified privilege. In contrast, qualified privilege does not apply to an employer who made repeated allegations against an employee without taking any steps to investigate the allegations, and instead relied entirely on accusations either made by other employees who could possibly be biased or on second-hand hearsay with no identification of sources. Bingo! It is a question of law whether any privilege exists, and the defendant bears the burden of establishing the existence of a privilege. So, qualified privilege. KJ may have to cough up her sources. Because if it's hearsay, so she can't say that she's got she hasn't pled fair reporting. She hasn't even done truth. I think she's pled opinions, but they're not protected. They're not automatically protected in defamation. The 4-factor test in Minnesota is whether the statement's broad content. Of course, it's a female judge. Yes, I know that, Cal, but I'm saying the judge was saying that she may be able to plead qualified privilege, and I don't know how she can plead qualified privilege, because my opinion is that she's relying on hearsay, second-hand hearsay, and she's going to need to plead qualified privilege. She's going to have to reveal sources, in my opinion. She can't plead absolute privilege. She can't plead Reporting that is fair and accurate regarding events in a public proceeding is protected. However, any commentary on that event or proceeding is not protected under fair reporting. So you can't even say that it is fair reporting. So, as I said, this is from her previous. Well, that's the thing, Anthony. How do you prove? How do you prove that so one of the allegations that has been stated, one of the claims is that, and she has stated it, we've all seen it, that she said that these people are engaged in waterboarding and human trafficking. So my argument is, how do you prove it? And how does she prove that what she reported was correct without revealing her sources? You see, that's where the confidential part, and this is where the semi-injunction and confidentiality stuff is going to also help her, because she will be able to say this is highly confidential, reveal her sources, knowing that only the lawyers and the judge are able to know. And in some cases, when those points are argued, they close the court. So this you know, so yeah, I don't know how she can prove it. Now, when we're talking about the case that Bruce Luhrmann has, he's now done he's taken defamatory action against the media and Lisa Wilkinson. I already am going to tell you they're going to plead the truth defense, probably, and qualified privilege. And it's going to be like Ben Robert Smith. We're going to see all the dirty laundry come out. So it's very interesting. So, as I said, I think I have issues of. It's interesting that the lawyers that are taking the Baz Luhrmann defamation case are the same lawyers that did the Barilaro defamation case, by the way. I just thought I'd state that. I just thought that was very, very interesting. So, I just find that whole thing to be interesting. Anyway, based on that, I'm going to head off, but that's my opinion. I can see lots of arguments that can go ahead here. So, hey, sorry, what happened with Baz? You mean who? Braz? Oh, I don't know what's happening to him. He's playing. So, all right. So, what the next step is? So, the next step is that they've got to now do all the depositions. So, they've got to give each other the witness list. Okay. They've now got to, and after October 31, there's also a date for mediation. So, it looks like that they've been. Looks like that they've got to go to leave. They've got to attempt mediation again. The other thing is is that, so there's no court dates there yet. But it's interesting here. I just want to tell you this, show you this, that it's now got a flag on it. So it says that it's open, protective order pursuant to Minnesota Civil Procedure, which means now, interestingly enough, we probably won't get a lot of the filings now because one or more, either party can ask for it to be confidential. So they may ask now that filings are confidential, which means we won't be able to see them. And all we'll get is judgments. It'll be just like an Australian case. So Bruce Lumen has... he is suing the media and Lisa Wilkinson for defamation. There you go. And Brittany Higgins allegedly has offered to give evidence. So former Liberal staffer has lodged 2 defamation cases, one against the 10 Network and the other against News Life Media. His trial was abandoned last year after a jury's misconduct, and prosecutors dropped the charge when they decided not to proceed with a retrial due to Miss Higgins' health. He's always maintained his innocence. The defamation action was foreshadowed in December when he retained Sydney lawyer Mark O'Brien. As I said, he's the same one that did Barilaro's. He'd been considering defamation proceedings. No details. Yes, I did see Michelle go live on her new channel. People said she wouldn't do it. So no dates or hearing, there's no mention or hearing dates listed. Under new federal court rules, details in documents handed to the court won't be made public until the initial mention or hearing. He's lodged several complaints. He's also lodged a formal complaint about the Director of Public Prosecution. So anyway, that is, yeah, so that's that one. I heard that as well, that's been a case. I'm assuming the girl is still alive, is still around. But see, it's interesting because I think those crimes are the only crimes that don't have a statute of limitation, I think. My arm's still very sore, Vedandra. I've got to go have an X-ray tomorrow and see a doctor. So she's 67. She's 67. Wow. Oh. Historic case. Oh, of course they're bad for everyone. So suing him and Millers. So a person is suing AFL legend Barry of Cable for over allegations he essayed her as a child. And has begun her ever court more than 5 decades. She's 67, name is suppressed, claims Cable, 79, abused her from the age of 12 to 17 in the 60s and 70s when he was at the height of his playing career. It's interesting how, and this is what I have issues with, they've suppressed the victim's name, but they've put his name everywhere. On the first day of the civil trial, it was revealed a second woman alleges that she was essayed by Cable as a child would be a witness in the proceedings. The plaintiff's lawyer, Tim Hammond, alleged Cable's abuse began with an inappropriate conversations and touching escalated to R and attempted R at a public pool in the change rooms of the Perth Demons football when she was 16. Interesting now, we're talking about 16. Anyway. Her life proceeds. Cable did not appear on the first day of the civil trial and was not represented by a lawyer. Judge said Cable, after several unsuccessful attempts to have the lawsuit thrown out and recent declaration of bankruptcy, had indicated he would not participate in the trial. So he's not there. He's got nobody representing him. So I'm interested. So a police investigation took place in 1988. No charges were laid. Cable said he had a consensual relationship for 3 years. This is what I'm really interested, though. This is what's really interesting, what interests me. How does it go about if the other side, because we have a law that you're innocent until proven guilty. Everybody has a right. If you, I don't know whether he's obviously filed documentation, so the judge can only make that documentation. I don't know how that works. So there were no criminal charges. It's been done civilly, which I find to be really interesting. So anyway, after all that, as I said, I'm going to head off now. I will catch you again later. Look, if you're on the replay crew, I'm interested to see what you think about what the judge has determined. What do you think? What do you think of what Katie Joy has stated the outcome was? Is there much of a difference? I think there is. I don't think she has entirely given the whole truth to her viewers. I don't think she's been entirely truthful. And the reason why I'm saying that is that she neglected to state that her motion to compel failed. And she also neglected to state that, a few other things. It's interesting how she, but then again, that's her bias and that's her right. But I don't believe either she should be making any statement or anything without speaking to her lawyer. I'm big on that. If I was her lawyer, I'd be telling her. I would be. I have no problem. I have no problem with a lawyer doing the talking. I don't have a problem of that at all. I don't have a problem with that at all. If she shared a statement that the lawyer had written, I'm okay with that. But when it's, sandwich strikes again, he's tried to destroy me and he's failed. That is just playing into all of their allegations about the fact that she just spurts everything out on social media. And don't forget, and she left this out, that the judge determined that there was a real fear that she would open her trap and spurt everything out on her social media platform. So I don't think she has come out smelling of roses. I think they've both sort of been told to cool it. That's my opinion. But we'll see how it goes. I think if it's a jury trial, oh yes, she's already posted and deleted today. Of course she has. Of course she has. Because her lawyers have probably told her, you can't be saying that. But, it's already too late. I have no doubt that 7M will be all over that. As I said, if it's a jury trial, it's going to be totally different to with a judge-only trial. Don't forget. So it will definitely be very, very interesting. There have been. I just don't know how she can keep doing what she's doing, the way she's doing it, and not realizing what's happening. You can't call yourself a journalist if you just dragging up, trying to find gossip. I mean, that stuff she wrote about, the fact that the Derricks were at the Grammys is proof that she hasn't destroyed their life, Hello? Seriously? What a really stupid thing to say. And saying that it's all... Yeah, anyway. Okay, well, thank you for joining me. Thank you. Yeah, she's spinning again. I was hoping that she was going to do a drunken live because I was wanting the drunken live, but we didn't get one. But look, if you could do me a favor, hit like on your way out. And if you could hit like on your way out, if you could subscribe if you haven't. See you for now. I'll be back. I don't know when I'll be back, but I'll be back soon. All the fun happens when I'm not home. So anyway, I've covered it now, and I've got my opinion. Yeah, as I said, I think it's the fact, for me, the judge didn't say she was, that they were. She didn't come out and say they are public figures. She said they are probably public figures. She said she may likely be a journalist. She may be able to use qualified privilege. The fact that Her Honour didn't come out and say it as a matter of fact leaves a big grey area and leaves a big debate and a big fight over those points. And I am here for it. And as I said, if I have to go to Minnesota for Christmas to go to the trial, I will do my best. Anyway, thank you for watching. Bye for now.